Did you? I didn't ask you if you read that piece on. You just thumbs up or down?
Oh, I love it. Spicy.
Okay, all right.
You guys in the YouTube chat need to relax, boy. Goodness gracious.
Yeah, we're feeling the pressure. Good morning, everybody. It's Monday, and people in YouTube, the dogs are in the kennel just snarling. Let's get it on. Yeah. All right, we're here. Back to Law and Legitimacy. It's yet another day in this, the best of all possible worlds. Still recovering from the aftershock of the D.C. Circuit's decision to ignore the First Amendment in the Owen Shroyer case. A lot of commentary on that over the weekend. I did a long interview with Owen Shroyer on InfoWars on Friday night. I know that's been reposted on X, and I thought we'd revisit the topic quickly here to address some of the critics. Did you know? And of course, if you're listening to Law and Legitimacy, you knew this, but did you know that I am the worst lawyer imaginable?
I knew that. I already knew that.
And so did I. And so do those self-righteous cocksuckers on the left who like to follow my career. And every time something doesn't go the way I want, use it as yet further proof that no one would hire in their right mind would hire me. Well, that may be. So maybe Owen's not in his right mind, and he has. So Owen, pled guilty. He pled guilty to a misdemeanor. That misdemeanor was entering and remaining on Capitol grounds on January 6th without permission to do so. And he pled guilty because he was guilty. And he would have lost on that charge at trial. Under federal law, he was to be sentenced under federal sentencing guidelines. And those federal sentencing guidelines amount to a cookbook, which assign a point value to everything. They assign a point value to the base offense level, offender characteristics, role in the offense, this, that, and everything else. And it takes a while to do a sentencing memo. Although the results of sentencing guidelines aren't mandatory on the courts must consider them. And so in Owen's case, the sentencing guidelines called for a sentence of, I think, somewhere between 0 and 6 months. The federal probation authorities who calculated it and made a recommendation to the judge recommended a walk, that is, that he not go to prison. The government wanted 120 days. Judge Kelly sentenced him to 60 days. And we argued at sentencing that a sentence of incarceration was inappropriate, and usually it was inappropriate because the government was arguing that Owen should be sentenced because of his speech. In other words, they accused him in a sentencing memorandum of peddling disinformation regarding the 2020 election. They accused him of incendiary speech prior to January 6th. They accused him prior to arriving at the Capitol of chanting such treasonous lines as 1776, death to tyrants. And we argued in the well of the court, hey, wait a minute. This is a trespassery offense. He was where he shouldn't have been. His protected speech and activities and right to petition for redress of grievances and assemble peaceably, those are rights that he's being punished for. The government is asking you to consider these factors in imposing punishment. That is an outrage. That's a violation of the First Amendment. That's an insult to the Bill of Rights and the core political speech values the Bill of Rights have always protected. Judge Kelly wouldn't have it, and he recited some of Owen's protected speech and conduct as reasons for sending him to jail for 120 days. We were outraged, or 60 days rather. We were outraged by that, and so we asked him to stay the proceedings while we took an appeal. Denied. We went to the appellate court, asked for a stay. Denied. So we filed a motion. We filed an appeal. When you're down in D.C. and it comes to January 6th and you ask for justice, this is what the judge says. And remind me, Mike, I'll tell you about my Friday morning if there's time here in front of Judge Moss, another jurist, who uses preparation age to clean his ears. Do the reasoning, folks. You'll see what I mean. But in any case, we took an appeal, and the government moved to dismiss it. And the grounds for the dismissal was that Owen, in his plea agreement, said he would waive, that is, forego the right to appeal any sentence of 6 months or less. In other words, if he was not sentenced to more than 6 months, he wouldn't waive. He would not appeal. And lo and behold, isn't that what we did? He got 2 months, and we took the appeal. Well, we took the appeal on grounds that the sentence imposed was substantively unreasonable because the judge considered as an aggravating factor Owen's protected conduct, his political speech, and his associations, and that was not covered by the plea agreement. In other words, punishing a person for their protected activity is always unreasonable. The government moved to dismiss. We filed our brief nonetheless. And last week, the appellate court, in a brief couple paragraph ruling, just basically said, yeah, he didn't do more time than what he pled to. The waiver is applicable, and therefore there is no jurisdiction to take the appeal, ignoring the First Amendment issues as if they hadn't been briefed, as if they don't matter. And therein lies the rub in this case and the significance of this case, because if allowed to stand, it stands for the proposition that protected political speech, your point of view, can be an aggravating factor in sentencing. In other words, you can be punished for the content of your ideas, even if those ideas are unnecessary to explain your criminal conduct. And candidly, if you don't see the point in that appeal, I can't help you. If you fell so hard out of the stupid tree that instead of landing on that ass, you landed on your head and knocked the sense out of you. Oh, well, when your ears stop ringing, give me a call and I'll explain it to you all over again. So we're going to file a petition for certiorari to the United States Supreme Court. It's due within 90 days of last Friday. So I'll get to it in the next month or two. And we'll ask the Supreme Court to hear the following question: whether it is ever permissible for a sentencing court to consider protected speech as a sentencing factor, as an aggravating factor in imposing sentencing. Under the rationale that supported its recent decision in Counterman versus Colorado, a true threats case, the court basically said we have to be careful not to chill speech with our application of the criminal law. That's exactly what happened in Owen Shroyer's case. So you haters out there who don't get it, press the rewind button, listen to this again. And yes, when I was talking about falling out of this stupid tree and hitting your head, I was talking about you. Friday was an explosive day in the federal courts for me in D.C. You will recall, you regular listeners, that I called in that day because I couldn't find my laptop when I ran out the door to go to D.C. Judge Moss sentenced Douglas Wyatt to 46 months in jail. And when I tried to explain to Judge Moss that Wyatt was there to listen to the president, and that he believed that the president was correct when the president said that the election had been stolen, and there could be no more outrageous an activity than a stolen election in a democracy, the judge wouldn't have it. He got angry with me, and sharp words were exchanged by both Judge Moss and me. In the end, we asked for 2 years. The government asked for 52 months. The bottom range of the sentencing guideline was 46, and that's precisely what Doug got. But I'll tell you, in this week's newsletter, you'll see an essay about judges blind to the reality around them. And yes, Judge Moss, I didn't name you in the essay, but I'll say it here. I was talking about you. I had a book with me as I traveled home from the Capitol, which I want to recommend to all of you. I'm holding it up now. It's by a guy named Ben Hamilton. And the title is "Sorry Guys, We Stormed the Capitol: Eyewitness Accounts of January 6th." So I've developed a more than professional interest in January 6th. Obviously, I tried the Proud Boys case, spent 5.5 months in trial in D.C. in 2023 defending them, and have represented other J6 defendants. And here's what I've learned from defending folks.
Before you share this, T-Girl asks a really insightful question here. Did you happen to tell the judge that you didn't appreciate the way he was treating you?
Oh, Judge, you can't talk to me like that. No, when you get T-Girl, so advocacy 101, you're there on behalf of your client, not yourself. And when you get a judge who's loaded for bear and he lets you know he doesn't like what you're doing, you don't pick a fight with him. You just move on because he has to make the decision. So no, I wish I had. I didn't have my my attorney Haba hairstylist with me that day, and my makeup wasn't on just right, and I hadn't done my nails. So what are you going to do? Good. But anyhow, so Ben Hamilton's an interesting guy. He's he's a former, I gather, high school history teacher who learned as a historian that the history of a given event is best told by documents and eyewitness accounts produced at the time of the event. And so he started something called the Chasing History Project. And several years ago, he began to travel around the country in a beat up old black van. There's a picture of it in his book, going to events, Trump events, election events, interviewing people who were present at the scene. In We Stormed the Capitol, he was present on January 6th, and he began to interview folks who were leaving the Capitol and had just entered. I recommend the book to you. His view is American civilization is in decline. Folks who were present at the Capitol that day share that perception and acted out on it in a number of different ways. He's not a Trump supporter. He's not a Proud Boy. He's not a member of Antifa. He is a candid observer of events in real time as they unfold. I haven't had a I haven't had a chance yet to check out the Chasing History Project online, but I'm recommending that all of you do so, because I think that what we're trying to provide here on Law and Legitimacy is a candid, non-ideological perspective on events as seen through the eyes of a couple lawyers. Ben does this one better. He asks about contemporary events as seen through the eyes of ordinary citizens. Now the comments are cracking Mike up, and
Mari came with a second hitter. Yeah, you shaved your legs for nothing, Norm.
I know I did, but on the other hand, it really helped when I put my pants on. I didn't have any snags. and tell me, Maury, exactly what pearls am I clutching, dear? In any case,
I think he was talking about the judge.
I'll tell you that judge. Oh, so check out today's newsletter. I got a little inspired yesterday and took some time to write a little bit about what I thought of that judge in the proceedings. It'll be in your mailboxes this afternoon. So the primary season is unfolding, and I am surprised this morning to read in a news source that both Trump and Haley will win Nevada. And I'm like, that's a pretty good headline. How's that going to work? And did you know, because I did not, that in Nevada, there is a state-sponsored primary, and then there is a Republican Party-sponsored primary. After 2020, Nevada decided to have state-sponsored primaries when Pete Buttigieg, the real cocksucker in the cabinet, when he started to complain about irregularities in the primary process. And so Nevada said, okay, we'll have state-sponsored primaries. The Republican GOP sued and said, wait a minute, this is a GOP function. We get to select our candidates. And so the courts ruled in Nevada's favor. And so what we'll have in Nevada are two beauty contests. We'll have a state-sponsored primary, which Nikki Haley is projected to win. Trump's not even on the ballot. And then we'll have caucuses from the Republican Party. And it is those caucuses which will choose where the Republican electoral votes go. And so next week, when Nevada has its beauty contest, you'll be reading confusing headlines. It'll be reported that Haley won the primary, but Trump won the caucuses, and Haley will take that win and she'll run around the country as though she has won something of value. What she will have won is a goose egg. No delegates. Trump is expected to run away with the Nevada caucuses and to walk away with all of Nevada's votes.
It was interesting in this article, and because I was very curious as to, I thought this was going to be an article about polling data and there being some conflict between polling, but boy, was I wrong. It was interesting that Haley, as well funded as she is, decided to be a part of the state-sponsored primary rather than the historical, long-standing Republican caucus in Nevada. That, to me, was a strategic and very intentional decision. And now she's using that. Her campaign is using that to say that, she will be disenfranchised because in the state-sponsored, those who participate in the state-sponsored primary are not obligated to choose one of the listed candidates. They can say none of these.
Yeah, that'd be interesting to see what happens there.
But so I think that's hilarious. It's like create a train wreck and then blame the other party on your own doing. So we'll see.
Well, Jackson Barrett, one of these days, I'll try. I've been laboring for a couple of years now to understand why Jackson thinks natural born citizenship means that a person who was born in the United States on American soil, but to non-American or non-citizens is not a natural born citizen. And Jackson has a long-standing beef with me and with this broadcast for failing to take his signature issues seriously. So he's in the chat saying, she's not eligible to serve. Now's your chance to talk about this, Norm. Still not ready, Jackson. It's not an issue that I care about. Obviously, you have to be a natural born citizen to be president. The courts have given it a meaning, and that is where you're born is where you're a citizen. If you are born on American soil, you're a citizen. If you are born on American soil, if you're born within the United States, but you're born to non-American citizen parents on the embassy grounds of your parents' home nation, let's say Pakistan, you're still not an American citizen because the embassy grounds are technically speaking not part of American territory. But we've adopted a rule that says if you're born on our soil, you're a citizen. Frankly, works for me. I mean, doesn't work for Barrett. Barrett says naturality is blood. I just don't know what that means. There is no such thing as American blood unless you're a Sioux, Cheyenne, or perhaps people who traipsed over the Bering Straits 14,000 years ago. This
You're my
notion.
law professor now saying consanguinity. Anyway.
Yeah, no, I just don't buy that. But and Jackson says, of course, watch Viva Barnes episode 169 to see two lawyers can't get it right. I don't know. I'm not a Bob Barnes fan. So Jackson, I appreciate that. I think you're wrong, and I just don't know why this is your hobby horse. It's not mine. Let's move on. There's something funky going on in the country, and you're thinking, you just now figured that out, Norm? No, I'm talking about a move toward licensing journalists. So Nick Hatziafatsu, Nick the Hat, we've got his post up there. I challenge you to pronounce that name. Nick Hatziafatsu. The only reason I can do it is I represented him in a case in Chester County in Media, Pennsylvania, a couple of years ago. He was accused of fabricating some information and was convicted and did a little bit of time. And he's done his time. He's come back out and he's determined to work as an independent journalist. But he's being locked out of events in Pennsylvania because he's not being recognized as a quote unquote legitimate journalist. He sent me this story about that, and I said, that just doesn't sound right. And then he sent me a follow-up piece about the Texas Department of Public Safety. The Texas National Guard actually gave a young man access to Shelby Park with other journalists to film the boat dock. But then two Texas Department of Public Safety people confronted the individual and said that you weren't a journalist and called and said, basically, you're a YouTuber, and he had to leave. It's a public park. And so, what's going on? We don't have licensed journalists in the United States. If you want to practice law, you've got to become a member of a bar. If you want to practice medicine, you have to get a license. If you want to become a journalist, you don't need a license. You don't even need a newspaper. The Supreme Court has recognized citizen bloggers as journalists. And the reason we don't have licenses for journalists is that's a form of prior restraint, and it's a form of government regulation of expression. And we have, on First Amendment grounds, a deep suspicion and repugnance to that. And so with respect to Nick the Hat in Pennsylvania, with respect to this person in Texas being thrown off or out of public meetings by public officials because those public officials don't regard them as journalists, that's a form what I will call constructive licensure. In the eyes of these public officials, these particular individuals aren't journalists within the mind of whatever the public officials consider a journalist to be, and therefore they're being denied access to a public forum to tell us what's going on in the public forum. That's dead wrong and cannot be permitted to stand. That is a form of government censorship that is one step removed, maybe just a half a step removed from silencing information the government doesn't like because it's misinformation or disinformation. Now, Mike's made us all painfully and gratefully and painfully aware of the fact that with respect to TikTok and social media, there's a lot of garbage being thrown out there, and a lot of it sticking to young people, to the detriment of those young people and to the detriment of our republic. But and I've pushed back against Mike in the course of these discussions, saying, you're right. But what's this, the solution might be worse than the cure if we've got to have regulation or licensure or government approval of what can be published, when, and to whom, and by what means. I don't know what the answer is to that larger debate that Mike and I are having, but I know what the answer is when adults turn up to cover public meetings on public property and public officials say, we don't like your kind around here. Get out. You're not enough of a journalist for us. That is a prior restraint. That is a direct assault on freedom of the press. That is a direct assault on the people's right to know. And I hope that Nick the Hat considers litigation to challenge this practice, and the young man in Texas excluded from a public event should do likewise.
Julian says this will only help accelerate the inevitable collapse of the mainstream media. I don't necessarily agree. So we've seen versions of this, Norm, and I think I've made reference on this stream before about a bill in Florida that DeSantis supported that was going to create a legitimate licensing structure for journalists in the state of Florida. That was
I missed that story. Wow, really?
This has been at least a year and a half ago, I think, and I'll have to go back and pull some of that. I remember reading through the proposed legislation at the time that it was coming down, and I believe it was also when we started seeing bills in state legislatures targeting anti-Semitic hate speech, Norm. And it seemed obvious to me that DeSantis was going to support and has supported hate speech laws geared toward the anti-Semitic hate speech, whatever that might be. But as part of that, and as part of what you're talking about here, and what Nick the Hat is trying to raise as an issue of constructive licensure, the state of Florida at one point was actually entertaining the idea of creating not constructive licensure, but active licensure, and requiring journalists to physically register with the state in order to be recognized as a capital J journalist for purposes of reporting. Which, again, we talk about how good of a governor he was and all this other stuff, but it's sort of, six of one, half dozen of the other when you're looking at DeSantis versus Haley. I mean, Haley was the one that was on record saying that she wants anonymity on the internet to go away, right? She wants everybody who's using a social media platform to be registered with the government so that the government knows who's saying what, where, and when, right?
Yeah, I mean, that I just can't help,
but this is
but to be outraged
this is
by
sort of
that.
ubiquitous, right? This is percolating everywhere. Anybody who's getting closer to those levers of power at a federal executive level seem to entertain this in a willing way. And what Nick the Hat is pointing out is that is actually being implemented just without any sort of statutory or regulatory regimes behind it. In this case, and then you referenced the Texas case as well.
Pseudonymous writings have been an important part of American political life.
Important is an understatement, right? Yeah,
then think of the Federalist Papers. I was taking a look at the Federalist Papers a little bit over the weekend. We're cruising along. Finally, got some momentum going on the con law lectures or course that we're offering on law and legitimacy. And I took a look at Federalist Paper number 1, written by Alexander Hamilton, but he didn't put his name on it. He wrote pseudonymously. And we've always thought that truth, at least in a democracy and in a republic, should be accessible to all. And that there aren't those who have an oracular perspective or vision that are to be trusted to the exclusion of others. That truth is every man's property. And if it is every man's property, then every man ought to be able to report on it. And thus we have citizen bloggers. The advent of social media does present a real challenge. And I candidly miss the editorial function of a well-curated news source. I don't trust the New York Times anymore. I like the Washington Post. I like the Guardian. But even there, you're aware of the thumbprint of the editor. The thing that I find so appealing about Ben Hamilton's book, and the Chasing History Project is here's every man out there on the street, and he's deciding that he wants to cover events, and he wants to talk to individuals, and he wants to report directly what those individuals say without being edited. Yeah, I like that. And I think there's some value to that. And I'm hoping we can get Ben on a long form at some point. But
Yeah, there's a couple comments over here on Rumble. In the cloud, good morning to you. In the cloud says, I watched his coverage of the escaped inmate in PA. He's very respectful and aware of others. Lots of integrity, something the mainstream media doesn't have.
this is
Agreed.
Ben Hamilton she's referring to?
Oh, she's
Oh, I
returning
didn't. Yeah.
the hat.
Yeah.
And
Oh, Nick the Hat. Yeah. Okay. Yeah. Yeah.
then Hans offers this. NYC has a city press pass system that you have to apply to get, and which I was not aware of that. Are you aware of the press pass system, Norm?
Yeah, I am. And that's the counter instance to everything that I've just argued. And so, the First Amendment permits government to promote reasonable time, place, and manner restrictions on speech and access to public events. And so, if you take everything that I've argued moments ago seriously, and you cannot prohibit any citizen blogger from attending an event, what are you going to do if you've got a room that can seat 100 people and you got 150 people turning up who want to cover it? You can't permit everyone to enter. And so
You ask what their opinion is on the matter du jour, and then you let those people in that you agree with us.
well, that would be a non-facially neutral means of determining who comes in and out. And that's what happened to Nick the Hat, and I think the fellow perhaps in Texas. But a facially neutral means of regulating access would be to say that you have to have a pass to come in. And when there are more applicants to attend than there are spaces, then we'll designate one person to be a representative of the press pool. This is common, for example, in so-called high-profile trials, where only so many seats are in the courtroom, or where you want to televise a trial in a state court proceeding and you don't want multiple cameras in there. You designate one news agency as the person or entity that can have the ability to broadcast, and others share. And in order to be eligible for the lottery, to have the one camera in there, they have to agree to share if they're selected. So it's a complicated issue. Life is complicated.
Julian says
And
you got to make the 150 bid in an access auction, and then of course Maury follows it up by suggesting Ticketmaster. We got a lot of jokesters in the chat today. I love it.
yeah, it's not a morbid Monday. I mean, here we are. We're getting ready.
All right,
Hey,
so tell us the Friday story. We got a couple of minutes here.
so Friday, government stands up. This was an assault on democracy. A sacred, tradition was undermined. And I'm like, oh, here we go again. Young prosecutor, relatively attractive, but in the eyes of one courtroom wit that day, she'd taken too much no ass at all. This stick-like figure who's up there talking about how horrible this was for the American Republic. And the judge is, and so I stand up and I say, Judge, there is another way to look at that, and there can be no more direct assault on a democracy than the theft of an election. And on January 6th, my client had come to listen to no less a person than the leader of the free world, the commander-in-chief, a man who garnered the votes of 74 million Americans, Donald J. Trump, who, whether rightly or wrongly, believed that the election was stolen. And I could see the judge starting to get the heebie-jeebies, the judicial heebie-jeebies, and I said, oh, I know there were all those
Pattis.
some 60 proceedings that held that there was no merit to this, and they didn't go very far. But do you really expect every American to read them? When did it become a crime to believe the president of the United States, or is it a crime only in these courtrooms because he's a member? Mr. Pattis, you're not helping your client. And what I wanted to say is, no, I'm trying to help you understand what's going on in the streets. Because it may be that as a result of that lifetime appointment and that insulation that you have from the ordinary cares of ordinary Americans and the cloistered life you live with others together in this building, protecting institutions and being masters of the swamp, it may be that you've lost sight of a crisis of legitimacy in this country, and you need to take your head out of that judicial robe posterior location, clean out those ears, and listen to what people were saying that day. It got tense. And when he said for the second time, you're not helping your client, I realized I was there not to help the judge understand things, but to minimize harm to my client. So I backed off, but I couldn't kiss the hem of the robe. And Mr. Doug Wyatt, a patriot, a 50-year-old man, who gone to listen to the president, heeded what the president had to say, was swept up in events at the Capitol that day, and, did engage in some knucklehead behavior, as he himself acknowledged, is now sitting behind federal bars, where he will sit for the better part of 4 years for the crime of believing as president, for the crime of caring about his republic. And the fact that our judiciary can't see that and continues to sentence people to prison so that this never happens again suggests a Pollyannish view of American history that any thinking person should find repugnant. If this judge were on the bench in 1776, he'd be sentencing the members of the Boston Tea Party to long periods of imprisonment because, after all, he disturbed the property of the East India Company. I think Doug Wyatt's point, and the point of everybody that appeared in the Capitol on January 6th, is this was the people's house. It was our house, and we have reason to believe that it was stolen. Now, it turns out, in the eyes of many, and mine as well, they were wrong. It may not have been stolen. But when no less a person than the president of the United States tells them it was, they should be granted a pass or some leniency. And rather than sending them to prison and radicalizing a new generation, we ought to be asking ourselves, what in the world is going on in this country that made that possible? But we have a judiciary that fails to look for deeper reasons and is succumbing to the juvenile rhetoric of the Justice Department, to the detriment of hundreds, maybe now thousands soon, of Americans. It is creating a sort of generational divide that will never be bridged in our lifetime. Shame on you, Judge Moss. Shame on the judiciary in the Judicial District for the District of Columbia in D.C. It was a bad day in court, Mike.
Well, I'm beginning and growing to appreciate your position on the 2020 election, in particular because of your representation and your zealous advocacy of clients who believe distinctly different from you on a common issue. And although you do have to absorb quite a lot of criticism for that, I think it's important for people to understand that duality and the fact that two things can be true. And at one time, we can all wrestle with countervailing viewpoints and still do what needs to be done. And in the case of Norm Pattis, it's representing people in front of the court and telling the truth about the matter, right? Rather than buying into a narrative one way or the other. So I just wanted to give you those flowers, Norm. Dawn says the most noticeable feature of a woman is her body, according to Norm. Care to respond to that, good sir?
Yeah, that's what I noticed. I mean, hell, I'm wired that way, Dawn. If you got a problem with that, what can I tell you? No, the most notable feature of a woman is the fact that she has a different chromosome and she perceives the world in a different way, or her voice is a soprano. Dawn, newsflash: the biological imperative is alive and well in the eyes of most. But I'm sorry if I've offended you, Dawn. You're a valuable contributor. But tell me, do you wear shorts when you play pickleball?
Here we go. Subscribe to the LAL newsletter at lawpoddaily.com. My question for you out there in the world watching us in real time is, who have you suggested Law Pod Daily, Law and Legitimacy to today? It's still early. It's 8:34 Eastern Standard Time.
And we've got a new edition coming out today, right, Mike?
We do indeed. We will have number 4 coming today in the essay that Norm made reference to just moments ago and earlier in the stream will be in full bloom and center stage in that newsletter. So we will we'll get that out to you all as well. Finally, Norm, I have gotten a confirmation text from our boy Mark Meckler. He's looking to schedule our long form. So I'm really pleased for us to get that scheduled ASAP and to offer that up to for our February installment of the long form for Law and Legitimacy. So we'll do that as well. Thank you, everybody, for being here. You can find us on YouTube, X, Rumble, at LawPod Daily. You can also hear our digital or our audio only on Spotify, Apple Podcasts, Google, Overcast, wherever you find premium podcasts. Please subscribe, leave us 5 stars. And again, I only ask that you just tell somebody that you like it.
And Dawn, you're not offended. I'm amused. You won't try to cancel me. Bring it, babe. Other people have tried. I'm like the bathroom fungus. Turn up the heat, I grow. See you tomorrow, folks.
We'll see you Wednesday, Julian. Bye, Norm.
Bye.